Recording to any evidence to courtroom.
Obviously the cross-examination is finished. You may have some things that you want to say as a result of the questions that you were asked. I'm not, you have to be careful you don't go over all your evidence again. You're entitled to comment if you want to make any additional statements as a result of the questions Mr. Bell asked, you can. So you can go back into the witness box on your formal oath. I require you to take the oath again. And if there's anything further you want to say about your case, please say so. But from the witness box, about the evidence. And then you're entitled to make submissions. All right?
All right.
Yes, I'm allowing you to make submissions given the nature of this case.
All right. When I make the submissions, will I just hand over?
Yes, or you can leave them into the record, whatever you want to do. Probably it's sensible to leave them into the record. You can edit your analysis as you go. And then that gives everyone an opportunity as to whether they want to respond. I guess I've not read them because there was something I should look at the If you want time to discuss that, I can leave the agenda. Discussion. Do you want to have a discussion or not?
I've just briefly covered it now, Your Honour, so it's
All right, otherwise I'll take you.
Yep.
Now you're on your former oath.
Yes.
You took the oath.
Correct.
So I'm just reminding you, as we do with every witness that goes into the witness box. So you should confine yourself to the evidence not to submissions as to the law, because submissions as to the law and any other submissions to the fact you can do as part of your closing submissions. And if there are any matters that questions that Mr. Bell asked that you want to expand on, you can. Mr. Bell will know what he's asked, and if you go down an area that we don't think you're entitled to give further evidence on, we'll stop you and talk about it.
Oh, right.
Yes. Well, I'm not, if you want to discuss it with Mr. King, I'll take an adjournment and you can leave the witness box and have the discussion. All right? Do not have the discussion with Mr. King once you have the witness box. All right? Stand up for the witness box. And I'll just take it. What are you taking?
It's my Bible.
All right. Your Bible.
Yes.
Oh. Thank you.
Thank you for this. The judge.
Just a number, everybody.
It's paper.
What's on them though? These things you want to read out or something? Are they part of your
so we can.
submissions that you've already put in
Yes.
the report? You don't have to. You'll speak to those from where you're sitting now.
Right.
Yeah. But we're talking about your evidence. And we're talking about, you remember Mr. Bell asked you some questions?
Yes, very.
Is there anything you want to add to any of those questions? You may, but it'll be privately controlled, so just, you can't depart on some other area that you might like to talk about.
Just the
Because
jurisdictions.
because you've done that already in the evidence and check.
Yes.
And so any response you make from the witness box should be concerning any question that Mr. Bell asked you. You might want to expand on it or might want to expand on some part of it. You don't have to, no need to.
Yeah.
And, so it's up to you.
Okay. Yeah, just a few questions regarding them.
Right, well, why didn't you put what's in the book?
That's just my one.
Your bio, sorry, I do. We'll take the bits of paper and use them help you.
Yeah.
Are they in your submissions?
No.
They're different.
The handwritten notes. Just handwritten ones.
Who from? Did you
From our
make those?
discussion.
Did you make those? You can't take those in, no.
Oh, okay. That's right.
Take them with you and we'll stop you if you don't like it. Mr. Bill, I'm sure we'll get to the stage where I'll stop you if we think you're going off track.
Okay, no problem.
All right?
Thank you. Okay, cheers.
What do you want to?
Just want to add on, as far as I'm aware, it was not against the law to record, and there was no duty not to annoy in public.
Well, you do, you. Yeah, all right.
Yeah.
Also, the submission you can make at the conclusion of the evidence, you say that there's no law.
Right. Okay. Should I carry on? Or?
Well, yes, carry on.
Yeah. My behaviour was not at the threshold of disorderly, and I have the right to defend myself against unlawful arrest. I believe I was not trespassed correctly, so I've not been given adequate time to leave and still have my family and property together, if that was the case, trespassed. That's it, Your Honour.
I have no questions, thank you. That concludes your evidence? You're not
Yes.
calling any witnesses?
No.
So you obviously want to make some submissions, do you? Read out whatever is on that piece of paper.
Yes, Your Honour, it has been filed.
I know that, but usually it's Mr. Bell, are there any submissions that you wish to make?
I Well, 1.9, I have Exhibit 2 here, which actually filed. That was the Authorities Act that was produced earlier. And Exhibit 1 is the disc, which hopefully is allowed you to install. Really, whether Your Honour wishes to hear from me on the law, whether Your Honour wishes to hear from me on the law or the facts or both. That's good.
That's pretty adequate, I think.
Yes.
But it may, given that Mr. Adams is self-represented, it may be helpful if
Yes, Your Honour.
what you say the law is.
In relation to disorderly behaviour, which is probably a good understanding as to what Mr. Adams is aware as he's attached the blurb from one of the police conduct books about disorderly behaviour. It's quoted from Police Supreme Court case. Yes, Your Honour. Essentially, as that reads, behaviour is seriously disruptive of public order, causing a nuisance. It must cause disturbance should a particular circumstance in time and place. Any effect that means the public are not reasonably expected to endure because of its intensity and or duration. The police's cases, his actions towards the staff member, following which in particular the older gentleman in the line, and then again the security guard and the Jetstar person again, all constitutes disorderly behaviour. I understand Mr. Adams has seen in the video perhaps frustration at being told that he can't film. The police's case is actions and continuing to film and the circumstances that took it beyond filming in a public place and actually amounted to disorderly behaviour. But in particular, the elderly gentleman, it's all on the video at the moment, the police cases that amounts to disorderly behaviour. In relation to trespass, the video outlines him being warned to leave and then refusing to do so under Section 3 of the Trespass Act. There is a defence available that Mr. Adams proved it was necessary for him to remain as he was concerned about his protection or protection of other person, or because of some emergency involving his property or the property of other person, none of which was in evidence. The video simply shows him refusing to leave and wanting to call Mark in relation to that. So he was warned to leave and remained, and then was arrested for that, and then the video shows him physically resisting. In relation to the element that he knew possible, Harry was an officer. She's clearly in uniform. Her badge is on that uniform. She is with another constable, and of course, it's what he usually could be willfully blind that she was a constable involving ignoring the true situation, and that's when those other aspects come into play. Accepting, however, that she did not identify herself in the video as Constable Schuster did. But in terms of the arrest, she was acting in execution of her duty after the trespassing. And Exhibit 2, just to jump back to trespass, Exhibit 2 allows the police to authority to trespass on behalf of the Auckland Court, which is a requirement under, I think it's interpretation under Section 2 of the Trespass Act. She was acting under the authority of any person of lawful occupation at that place, and that's what Exhibit 2 gives her the power to do. But unless I can suspect some, I can expect only later after Mr. Adams.
Yes, Mr. Evans.
Okay, Your Honour, the hearsay testimony during the hearing of 21st November 2023 will testify Senior Constable Cherie here in response to being asked if her use of force against Mr. Adams at the time was reasonable or justified. Senior Constable Cherie here referred to the video she had viewed several days after the alleged incident, stating that after seeing Mr. Adams' interaction on the video with Binky Bill, that yes, her actions were reasonable and justified. Mr. Adams wished to bring to the court's attention that Senior Constable Cherie here had only attended Auckland Airport on that day after this interaction between Mr. Adams and Binky Bill, and had no first-hand primary knowledge of this interaction. Senior Constable Cherie here's knowledge gained from the video post 16th July 2022 as hearsay and as such is inadmissible. The mens rea, the prosecution has not to date established the existence of mens rea in these proceedings. This is fundamental to the case. No case can be pursued against Mr. Adams due to lack of establishment and intent to commit any of the alleged offences before this court, and therefore due to meritless case, no case against Mr. Adams. Exhibits relevant law and administrative law. Exhibit B1 is Section 14 of the New Zealand Bill of Rights Act in 1990, which affirms Mr. Adams the freedom and right to speak, receive and impart information and opinions of any kind in any form, including, however not limited to, using his cell phone in a public place such as Auckland Airport to document poor behaviour and service displayed by Jetstar management on 16 July 2022, and for his protection when approached by New Zealand Police. Exhibit B2, Section 5 of the New Zealand Bill of Rights Act 1990, showing that any limitation to rights affirmed within PORA must be demonstratively justified. No such limitation has been demonstrated, and of no evidence of any prohibition on recording has been produced by any witness or the prosecution, and no signage prohibited recording at Auckland Airport are posted. Exhibit B3 is page 8 of 49 from 10.1, New Zealand Police Intranet, released under the Official Information Act 1982. New Zealand Police instructions on behaviour offences, specifically defining that a public place includes any airport within the meaning of Section 2 of the Auckland Airport Authorities Act 1966, which Constable Aaron Schuster read during his testimony on 21st 2023. However, he stated that this depended on what Section 2 of the Airport Authorities Act 1966 defined as an airport. Exhibit B4 is Section 2 of the Auckland Airport Authorities Act 1966, showing the definition of airport and confirming that Auckland Airport is indeed an airport and therefore a public place. Exhibit B5 is Section 2 of the Summary Offences Act 1981, interpreting a public place as meaning a place that at any material time is open to or is being used by the public, whether free or on payment of charge, further confirming that as Auckland Airport was open to the public on 16 July 2022, it was and is a public place regardless of it being private property or not. Exhibit D6 is Section 2 of the Crimes Act 1961, showing the interpretation of assault, given that during Constable Aaron Schuster's testimony, he was uncertain what assault meant. Therefore, to assist in clarifying what assault means, Ms. Adams submits that assault means the act of intentionally applying or attempting to apply force to a person of another, directly or indirectly, threatening by any act or gesture to apply such force to a person of another. If the person making the threat has or causes other to believe on reasonable grounds that he or she has present ability to effect his or her purpose and to assault has a corresponding meaning. Ms. Adams submits that Senior Constable Sheree Hare testified to both threatening to use force and without reasonable grounds use force to make or affect Mr. Adams' purpose and prevent Mr. Adams in the exercising of his rights at the time of the incident as shown on the video evidence, without any justifiable limitation, namely to stop him recording and documenting the incident and interactions. Exhibit D7 is Section 4 of the Policing Regulations 2008, showing the information that evidence of identity and authority must bear and state, given Senior Constable Sheree Hare prevented Mr. Adams from documenting her ID and failed to identify herself upon request. This behaviour by Senior Constable Sheree Hare, due to either a delusional or misinformed expectation of privacy or prohibition on recording at Auckland Airport, appeared irrational and unreasonable and did not instill Ms. Adams of any trust or confidence personally in her training, knowledge or abilities. If Auckland Airport was, as she believed, a private place or private property, how can Mr. Adams even be charged with disorderly behaviour as an element of this offence? It was that the offence allegedly occurred in public or within a public place. Exhibit D8 is Section 48 of the Crimes Act 1961, which Mr. Adams submits as a response to the allegation of resisting police, as Mr. Adams was unjustifiably assaulted several times by Senior Constable Sheree Hare. He believed he was justified in using, in the defence of himself, such force as, in the circumstances, he believed was reasonable to use. Exhibit P9 is page 14 of 49 from 10.1 New Zealand Police Intranet, released under the Official Information Act 1982. New Zealand Police instructions on behaviour offences, specifically defining disorderly behaviour as being behaviour that is seriously disruptive of public order. It must cause a disturbance to public good order, which in particular circumstances of time and place, any affected members of the public could not reasonably be expected to endure because of its intensity and or its duration. And cites Crawford vs. Police 2007, NZSC 3 that his behaviour at the time did not constitute disorderly behaviour. Mr. Adams did not raise his voice or act disorderly in any way. Any escalation of the events on that day were created by the behaviour and actions of Senior Constable Sheree Hare at that time, as her sole issue during the entire interaction appeared to be that Mr. Adams was recording, which was perfectly lawful activity. Mr. Adams submits that Senior Constable Hare had not escalated the matter of making threats and then using force against him in an attempt to make him comply with a request that he was not lawfully obligated to follow. The incident would not have escalated further. Mr. Adams' sole intention was to arrange and available flight to Queenstown and leave if he had not been told by the Jetstar manager to arrange a flight crew. He would not have. If he had not been assaulted by police for exercising his right to record in public, he would not have had to use self-defence against such. Mr. Adams regrets the events of 16 July 2022 that happened and acknowledges that he could have handled the situation better in hindsight, but maintains his innocence against the alleged offences before the court. Thank you.
Just briefly, I should have mentioned before on the men's grey disorderly behaviour, Your Honour, and Adams on criminal law, which is legal textbook, not Mr. Adams.
Adams on criminal law. Put Adams on criminal law, which all lawyers use. So I think what Mr. Bell was saying has got the clear. The name of this textbook, it's a spec. Well, it comes in multiple volumes of this size, but it's for anyone, is a leading text that everyone uses.
The commentary there, 41A, which is the section Mr. Adams is charged under, disorderly behaviour doesn't have any specific intent listed as opposed to the other sections of 4 do. The authors say the conduct in question will have to be deliberate and not accidental and voluntary. But the cases have left it open as to whether mental behaviour is required. It does go on to comment on awareness of annoyance and likelihood of annoyance. And I submit that those two are made out from the videos, the continuing videos of Mr. Adams' comments throughout, the make famous comments and putting it on YouTube and various things. There must be an appreciation there of their annoyance when they're telling them to stop filming and the like, especially the elderly gentleman. There's awareness that this conduct might cause concern has been held sufficient in case law in relation to that, but there isn't a specific means grey element for
Anything further? Alright. Well, that's the conclusion of this matter. The issue now is whether you might proceed to decision, because I'm going to reserve it. The market effects 7 days, and we've had the evidence tied up. And there's no more time available really this year. So I've got a nominal date of the 16th of February 2024 at 10 a.m. For the next hearing when I'll deliver my decision. Alright. So you're remanded back to continue, is that your date?
I'm available.
To the 16th of February. Does it cause you any problems on 16th?
It should be fine.
It may change depending on how our rosters change constantly. That's the only risk, but you'll be notified when in advance. Or if it gets called on earlier. So I'm sorry if that gives you Christmas, but sometime maybe possibly before the 16th of February.
Thank you.
Before we get into the part of
Thank you.